the internet LEXIS and Company, and today we'll be talking about the process of winding up of company. The winding up of a company refers to the process of bringing its affairs to a close and ultimately dissolving it. The specific process may vary depending on the jurisdiction and on the circumstances under which the winding up occurs. However, I can provide a general overview of the typical steps involved in the winding up of a company. Here is the key. First, board resolution or shareholders meeting. Second, appointment of liquidators. Third, notification and advertisements. Fourth, compilation of company's assets and liabilities. Fifth, settlement of debts. Distribution. Sixth, distribution of remaining assets. Seventh, dissolution and removal from register. First, board resolution or shareholders meeting. The decision to wind up the company is usually initiated by the board of directors who pass a resolution recommending the winding up. In some cases, a shareholder meeting may be required to approve the decision. Appointment of a liquidator. A liquidator is a person or a professional firm responsible for overseeing the winding up process. The appointment of a liquidator may be done by the company's members or through a court order depending on the circumstances. Notification and advertisement. Once a liquidator is appointed, there is a requirement to notify the relevant authorities such as registrar of companies about the decision to wind up the company. Additionally, public advertisements may be necessary to inform creditors and other stakeholders. Compilation of company's assets and liabilities. The liquidator gathers information and compiles a comprehensive list of the company's assets, including properties, cash, any outstanding debts or liabilities. Settlement of debts. The liquidator notifies the company creditors about the winding up and sets a deadline for them to submit the claims. The liquidator then assesses and verifies these claims and proceeds to settle the outstanding debts to the extent possible using the company's available assets. Distribution of remaining assets. After seeing the debts and liabilities, the remaining assets, if any, are distributed among the shareholders according to their respective rights and entitlements. In the case of a solvent winding up, the distribution is usually in proportion to their shareholding. Dissolution and removal from register. Once all companies' affairs have been wound up and there are no further assets and liabilities, the liquidator applies for the company's dissolution. After receiving the necessary approvals, the company is struck off the registrar and its legal existence is terminated. It's important to note that this is a general outline of the winding up process, and the actual steps or requirement may vary depending on the jurisdiction and specific circumstances. In some cases, court involvement may be required, especially in insolvency-related winding up procedures. It is advisable to consult with legal professionals or experts in the relevant jurisdiction for specific guidance and compliance with applicable law and regulations. Now I would like to wind up my topic, and if case anybody is having any doubt, they can ask me in the comment section. I will try to reach out to you guys. Thank you very much.